Good afternoon, everyone, and thank you for joining us today for Mayor Brown's discussion regarding navigating U.S. agency subpoenas. My name is Richard Rosenfeld. I'm the co-head of Mayor Brown Securities Litigation and Enforcement Practice. I spent about 8.5 years in the enforcement division of the SEC in a variety of different job titles, and following a stint in private practice, went back to the government and oversaw the TARP bailout program prior to coming to Mayor Brown to head up its enforcement group. Focus of my practice has been and remains representing clients before the SEC's enforcement division, defending those investigations. But probably more important than me, joining me today are my partners, Chris Leach and Ori Lev. I wanted to take a minute to have each of them introduce themselves as well, not only because it's only fair, but also because they're great guys and have had really impressive careers. So I thought we'd let them introduce themselves. Chris, do you want to start?
Sure, I'm happy to, Rich. It's very kind of you. So my name is Chris Leach. I'm an attorney in the DC office. I'm a partner in the litigation group. I've been at Mayor Brown now for just over a year. Prior to that, I was at the Federal Trade Commission in the Division of Financial Practices, where I ran and was in charge of mostly investigations involving fintechs and other sort of consumer finance issues. As part of that role, I also was the program lead for the cryptocurrency program, really throughout the agency, which is now, as many might have seen from the news, is apparently much busier than when I was at the agency. And I'm happy to talk about that with folks. But at Mayor Brown, I help companies in FTC investigations on the consumer protection side. And I also do counseling and litigation involving advertising and marketing issues. Ori, I think it's your turn.
Hi,
you took my words.
I'm Ori Lev. I'm a partner here in DC as well. I also come from government. I was an enforcement attorney at the FTC many years ago. I served as the head of enforcement at the Office of Foreign Assets Control at the Treasury Department, which implements U.S. economic sanctions. And then I was at the Consumer Financial Protection Bureau, or the CFPB, in its early days, helped stand up its Office of Enforcement and served as a deputy enforcement director there. And now at Mayor Brown, I represent companies in CFPB, OFAC, and FTC enforcement actions, and also provide advice and counseling on unfair, deceptive, and abusive acts and practices. And with that, I'll turn it back over to our fearless leader, Rich.
I like that I'm suddenly the leader. I feel like that's putting more on me than I was ready for today. But let's talk about what we're talking about today. What you have in front of you are topics that we're going to cover. You heard the sort of, if you take me out of it, the impressive backgrounds of the folks on this panel here today. We thought we would try to give a general overview of not only what the enforcement environment is like these days, but also what are the steps and stages of an enforcement investigation, of a proceeding, from the standpoint of the SEC, the FTC, and the CFPB. There are similarities, there are differences. Ori, I know we've spoken a bunch of times about how when the CFPB stood itself up, which you were an integral part of, it was, in some ways, it copied other agencies. It took things from the SEC, it took things from SIGTARP, it took things from a variety of other agencies around it, and then made them their own. And so there's some really significant differences, which I've enjoyed over the last couple of weeks, chatting with Ori about what they are and what we're going to talk about here today. But we're going to walk through what happens when you get the knock on the door, when you get the email that encloses a subpoena or a request letter, and think and talk you through sort of the things to think about with that. Essentially, we're going to take you all the way through what you should do at the very beginning, what you should be thinking about, what the agencies are thinking about, and then importantly, how to think about the long haul, how to think about everything surrounding it, third parties, disclosure issues, everything you need to think about, but then also how long these agencies take and what they think about. With that, I think it makes sense to go to the next slide. And I'll start us off. Just a little bit of an overview of the environment. The SEC puts out its priorities in both from its exam staff and its enforcement staff every year. And I will say that those priorities often remain the same. Insider trading is always a priority. Conflicts and other disclosure items are always a priority. But I wanted to focus a little bit, especially with having Chris here on the panel, and it's very opportune on cyber and crypto and how the SEC is thinking about that these days. I say it's very opportune because in the last 48 hours, a host of things have happened. The SEC in the last month has put a listing up for one or more job openings in its crypto assets and cyber unit, which is growing by leaps and bounds. Last May, it announced that it was going to add 20 additional positions to crypto and cyber in the enforcement division, which doubled the size of that unit at the time. And then before Congress, just a couple of weeks ago, the chairman of the SEC, Gary Gensler, said that crypto-related activities have stretched the SEC thin. And asked Congress last month for an additional $200 million on top of the funding they already get, which is nearing $2 billion on an annual basis. So a 10% more in funding right now. Very unusual for a government agency to ask for 200 million more midterm, and asked for it specifically to hire 170 additional employees for data analysis, information technology, but mostly in the enforcement and examination space in this area. So, that says nothing about the amount of cases and the new cases we're seeing coming out of the SEC. If people have seen Payword, which is better known as Kraken, came out recently, and that's a staking case, and the SEC, I would say, is really staking its ground. This is all about turf. Thanks, Chris, for at least smiling. I hope anyone out of all the people listening smiled for my pun. I've been working on that all day, but it really is. I think this is all about turf for the SEC. They want to be as broad and as a part of this area as possible. So you're going to see, as it was in Kraken, right? It's a failure to register. They're going to be going after crypto in many areas of not registering as a security, trying to make as many crypto type assets and things you can do with it, transactions. Staking is a great one where you give back your cryptocurrency to the firm and see if you can get more. That whether that's a security or not may have been an open question. The SEC settled a $30 million case right here on purpose, because they wanted to show that this was a space that they were in and that you have to register. I'm going to throw it to Chris because he was such a part of this world at the FTC, and this is what he's been doing the last year with us. But I think hopefully that's a good segue for you, Chris. It didn't give everyone a true flavor of all the things the SEC is doing, but it's certainly the hot topic of the day.
Yeah, no, I mean, crypto, even though they say crypto winter, crypto is hot, at least in enforcement context. And without sort of incident somehow making this a crypto webinar,
right.
but I mean, that is in terms of trying to figure out sort of where the FTC falls in fintech. Sometimes sort of when people are thinking through, like, who do they need to be worried about? Everybody thinks the SEC, because that's how you get your money. If you're doing financial services, it's the CFPB because they do consumer finance, but the FTC is often one that folks don't think of, but they really should. I mean, in the fintech space, if you're not a bank, then you are doing, quote, commerce, which is literally the jurisdiction of the FTC. And so in areas like neobanking, anytime you have a fintech banking partner, that non-bank fintech is going to be subject to FTC jurisdiction. With respect to crypto, I'll just highlight I'll echo what Rich has said, is that recently there's been a lot more activity. Right now, nothing public, but there were some articles that went around where the FTC's press office confirmed the existence of investigations involving unnamed entities, but the subtext seems to be that basically the largest and most prominent folks in the crypto space are likely are dealing with FTC CIDs right now. And the way that the FTC looks at this and really looks at all of their matters in this case is that they have at this, like any other agency, a series of models that they're looking at. And so for in the crypto space, I mean, if you're dealing with consumers, you're making claims about what type of product you're buying, how much of it, how much does it cost? Are you actually delivering the service to customers, or are there issues? And these are just the same building blocks that you literally see in any type of consumer protection case, but where the widget that is the central focus of the concern is crypto rather than some other product. The other area that I just want to note that I think there's been a lot of attention on, obviously, given given how much fun we had with ChatGPT over Thanksgiving, is the AI space. And I won't belabor that because right now there haven't been any cases really involving AI right now, but this is an area where I think the FTC at least is focused on two sides of things I want to just highlight here. One is just claims about AI. Like if you're saying we use AI to do blank, the basic thing is just like making sure that that blank is actually true. We know often from an in-house legal side that the marketers can sometimes get over their skis, and especially in an area where sort of technology is like quickly developing, where folks might not have a full grasp of what it can actually do, that's going to be something that could be easy pickings from the FTC. And the other area that they're focused on is sort of safe design, seeing folks who develop AI tools as giving folks the tools to effectively commit wrongdoing or to inadvertently commit wrongdoing. And that's an area where I'd say it's sort of pushing in sort of avant-garde area of what is an unfair or deceptive practice, since it's sort of like creating an illegal bazooka in that regard. You're developing something that is dangerous. But that's, I think, where the FTC would be thinking about this, but I think it remains to be seen like how they're going to do that. But I think this is all because they're going to be developing these cases. Subpoenas are going to be going out, which is why this is, I think, an important topic. But I'll go to Ori just to highlight some of the things that the CFPB is thinking about in tech.
Hey, Ori, no pressure, but you're going to have to be as creative as a legal bazooka. I'm really curious.
Yeah, I'm going to fail on that front. But so that, like the SEC, the CFPB went on quite a hiring spree in its enforcement office. We haven't yet seen the uptick in enforcement actions, but I'm pretty sure they're coming. What we have seen from the Bureau is a lot of other activity in the fintech space. So a lot of orders, both compulsory and non-compulsory requests for information. We've seen it in the buy now, pay later space, in the big tech space on payments issues. They recently issued a request for information on data brokers, and which was defined very, very broadly. That's related to the rulemaking they have on open banking. And we've heard a lot from them about issues that relate to fintechs. Algorithmic bias has been a really big deal. So if you're using AI to make decisions, you better be able to explain those decisions and make sure that they're not discriminatory. We've heard a lot about dark patterns, which Chris and I's favorite phrase. It's really just a scary way of talking about deceptive user interfaces on the web, but dark pattern sounds better than just saying deception. Data aggregation issues. Rohit Chopra, the CFPB director, is extremely interested in how companies are using, or in his view, misusing consumer data. And lastly, I noted competition. And the CFPB is not a market regulator, but Chopra has really been viewing the consumer protection lens in many ways through an antitrust, the consumer protection issues through an antitrust lens, and thinking about how established large companies have advantages, and what are they, are they doing things that harm consumers and that are keeping out new entrants to the market. So those are some of the issues that I think we expect to see develop into, ripen into enforcement actions on the CFPB side.
So before we throw it to the next slide, and let's go to the next slide, but we had a question, and I just want to take 30 seconds and answer it about gatekeepers. And it asks whether or not the SEC has been focusing on gatekeepers or private investment funds, and each of you are happy for you to jump in. The SEC has announced publicly 3-4 years ago now that they think that fraud doesn't happen in a vacuum, and that they are going to increasingly target individuals, whether it be accountants who helped out, attorneys or employees in the, C-suite employees, directors, officers, whoever it may be, including folks in the industry or gatekeepers who help out. And we have seen a couple of cases now. It's tough for them to go against attorneys, but we have seen them go against an attorney in a fraud case at the end of last year. They have certainly been upticking investigations and cases against auditors, and there is a real push to change some of the audit rules and formats that the CFPB is pushing. I'm sorry, that the
CFTC?
No, it's the accounting board. But I'll think of it.
PCAOB.
PCAOB. So sorry, literally, my friends all work there, and I'm now in a lot of trouble. But the PCAOB, I was looking at Ori at the time and could not get CFPB out of my head. The PCAOB, thank you, everyone, has been ramping up its enforcement requirements for accountants, and we're going to see more in that space as well. So yes. Definitely, we've already seen an uptick in gatekeepers, and we're going to see it more. Same for you guys?
I would say, I don't know about like using the gatekeeper moniker. There's the FTC has sort of a robust practice in the past like 4-ish years of individual liability. And that's sort of like going after mostly CEOs and other sort of responsible individuals. But in certain cases, I think there was I forget, it was a lead generator where they sued not only the lead generator, but also the CEO, I think the CFO, and then the GC as well. So they will go after lawyers, but I wouldn't call it as like a gatekeeper function. It's just as another, quote, responsible person. But I feel like it's rarer that you see folks in the GC context as a respondent to FTC issues. But Ori, is that a similar experience?
So the CFPB's long gone after sort of CEOs of small, closely held corporations. More recently, we've seen they did bring an enforcement action against an executive at TransUnion who was allegedly responsible for making the decision that they're challenging as violating a provision of a consent order. So I think that's something Chopra is interested in seeing. And of course, we've seen the prudential regulators go after some individuals in some high-profile banking cases recently. I think the CFPB is going to want to piggyback on that. So haven't seen it with respect to, again, gatekeepers specifically, but certainly individual liability is something to be aware of.
Got it. So yeah, so with that, I think we'll turn to the actual sort of meat of the presentation. And so these first sort of 3 slides are talking about like basically in the first like day or so, like you come in the morning, you get your coffee, you think it's gonna be a great day, and then your corporate designee from someplace in the country says that, hey, we got this email, we got this letter, and it's a CID from an agency, from the SEC, from the CFPB, the FTC. And so what we're going to lay out right here is here's sort of what you can do and what you can learn like in the first like couple days to try and get on top of these, because getting on top of these is sort of an important first step, just because these processes can, even though they last for a while, they start off relatively quick. So the first stage is obviously we'll talk about the subpoena, and we're also here going to call it a CID. In FTC land, and I believe in the other lands too, they call it a civil investigative demand, which is a CID. Subpoena is literally the same thing. So that's, we might sort of interchangeably refer to those here, but the first thing obviously is when you get the subpoena, you should read it. It's obvious, but I mean, and I'm not just saying it because that's going to define sort of what your obligations are, but there's some really important information that I think if like your board is asking, hey, so what is this about? The first is that normally you can very quickly understand, like, one, is your company the focus of the investigation? I know that at least in the FTC, every CID has a section called subject of the investigation, where it will say you or some other company, and then list essentially the statutes that they think you might have violated. Granted, a lot of it is boilerplate, but understanding whether or not you are the the target, and what statutes they're thinking about as they draft the CID can actually be really helpful, because then looking at, I'm going to skip to the bottom, like looking at all of the specifications, the interrogatories and document requests can really help you sort of try and figure out at least what in their mind's eye they think that you're doing. And this can be a couple different things. That if you have a company that is, I would say, sort of in a new area, doing a new activity that the agency hasn't really enforced in the past, you can take a look at their specs and see, are they trying to sort of put you into a particular bucket? And so from the FTC's perspective, like they have a lot of cases against payment processors, folks that help like take merchant funds and transmit it to bank accounts, et cetera, like that. And there's a number of sort of classic specifications that they'll put in to try and figure out if they think you're a payment processor, these are the types of questions that they're looking at. Or if you know that your client if you know that your company has like a number or sort of a smaller number of distinct services, the questions there will, I think, help very quickly help you figure out what do they think is going on. Because often what's happening is they will have taken a look at consumer complaints that filter through either state AGs, the agency directly, or Better Business Bureaus, and they'll have heard concerns about particular business activities, and they will then sort of use that to try and target, to the extent that these CIDs are targeted, because some can be very broad. They'll try and target the particular activities that they want to look at. And then lastly, I'll just hit here before I give Rich and Ori a chance to chime in here, is that the date ranges is also important, because obviously if it is sort of more narrow in scope, you'll have a sense about what like the potential sort of landmines you might be aware of, or some issues that the company might have had in the past. I'll say that can often be less helpful, because oftentimes it's just the statute of limit. They'll just go back however many years from the statute of limitations. So it's sort of, they have targeted-ish CID specifications, but basically they're trawling for tuna with a really big net. And so, but you can often sort of figure out sort of what might be out of scope with the date range as well, which is always helpful. But Rich and Ori, like what's I've sort of given my take from the FTC. Like how does this work? Is there anything different for CFPB, SEC?
So I'll just jump in real quick on the CFPB. I mean, the CFPB's statutory authority to issue CIDs is literally a cut and paste job from the FTC Act. And when we were at the CFPB and we're putting together our rules of investigation, as Rich alluded to, we looked to a lot of agencies, but given that cut and paste statutory job, the rules are very similar to the FTC rules. So, very, very similar to what Chris said. The one thing I'll flag for the CFPB is there is specific language they use. If you're not the target of the investigation, there's going to be this language in the instructions to in the CID that says, please keep this CID confidential. And if it says that, then that means, oh, this is a third-party CID. They're investigating somebody else, and that's why they're asking us to keep it confidential. If it doesn't say that, much better likelihood that you are, in fact, the target of the investigation.
That's really interesting, because the SEC will always say, and has always said in its entire history, that it has no targets, that it is a finder of fact, and the laughter is correct,
well,
by the way.
I'll just jump in, Rich. I mean, when I was there, we talked about this at the CFPB, and I misspoke. The CFPB will say you are the subject of an investigation,
well,
not the target for that very reason. But
right, No, but the SEC would say it has no subjects either.
No,
right?
Well, the CFPB definitely has subjects.
They're just guys asking questions, Rich.
They say they're finders of fact, and that they have found nothing until they have made determinations, and so there's none of that. It is very unless it's, and this often happens, it's in the matter of the name of the investigation is in the matter of ABC Corp, and your ABC Corp, you don't necessarily know whether it's about you or about someone else. And even if it is, by the way, just because they've named it, it's in the matter of ABC Corp. If DEF Corp bribed ABC Corp, it's in the matter of both of you, right? It doesn't matter what the title is or not. And the same thing for individuals. It's very hard necessarily to determine that just from magic language in one way or another. There are a lot of things you can glean, though. The SEC, there is magic to this, and the SEC has a lot of different ways to do this. I'm conscious, as I knew amongst the three of us, because I enjoy talking to you guys so much, that we're already 26 minutes into this hour-long presentation, and I don't want to do this forever. But there's all sorts of things and nuance you can glean, as Chris said, just from reading the thing when you get it. For example, the SEC doesn't always send a subpoena; they just send what's called a request letter, and it's a voluntary request letter. And that request letter can mean that they don't have subpoena power yet, which means it's just an inquiry or a matter under inquiry. They often call them MUI, or it still could be a formal investigation, but they've just voluntarily asked you to do something. The voluntary request letters I always find humorous, because if you choose not to answer the voluntary request letter, their next step, which you can, it is voluntary, they will agree, you don't have to answer. Their next step, of course, will be to immediately subpoena you. And so then you will receive an almost identical letter of request that attaches a subpoena for usually the identical information, unless you've just made them more curious or more skeptical now, and they will add all sorts of extra questions in. So most, if not everyone, chooses to voluntarily respond and cooperate as much as they can with the commission's investigations. But these are all things you can sort of glean. You can also glean how long the individual who is asking you has signed the letter has been at the commission, less than a year or more than a year, just by their title. There's all sorts of little things you can figure out. But more importantly, and Chris has already gone through this, is to pay attention how they define the entities they're looking into, whether they define individuals in any specific place, the time periods they're looking into, whether those time periods change in certain of the requests or questions that they've asked, right? Because some questions will have 2017 to the present, and some will have from the months of April to June 2019. And you're like, okay, what is happening right here about that very issue, which Chris has explained before. So all that is the key to when you first get this information in the door.
Mm-hmm. So now we'll go to the next slide, and just this is going to be very quick, because as lawyers in-house, we understand preservation for when we get a lawsuit, and this is sort of just basic stuff. But we want to flag this because, again, most of your companies likely have automatic data retention and auto delete policies, and so it's going to be very important to take a look at the CID, see what they're looking for. Look at it holistically, not sort of, we're not, even if when you actually respond to the CID, you might sort of take a Nixon judge strict construction approach to these requests, when with respect to the preservation issue, because of the issues that can happen if you have not sufficiently preserved documents, it's often safer to take a look sort of a little bit broader than you might actually end up producing. But it's really important to get a hold of your document retention and auto deletion policies. And that's normally pretty easy on email. It's sort of, you have your email, whatever your server is, whether it's Gmail or whatever. I don't do the technology stuff, so I'm not going to tell you all of the names, but whoever you're using, suspend the auto delete policy to the extent that you need to for this investigation, whether it be just for particular individuals or you think like sort of teams who are the subject here. But that's really just one piece of the pie, because there's going to be a number of other sources of information that they're going to need to consider. I mean, the most important, well, not the most important, but like the thing that the agencies are often very focused on are Slack and other sort of more informal texting things, because they've seen we all know from the I think the LIBOR case, where basically the best documents all came from some sort of Slack chat channel. And so those are the types of things that they always ask about. And I know oftentimes there are much more strict auto delete procedures. So you might only have Slack that goes back 6 months, which is totally fine. But you're going to want to make sure you shut off that light. when you get this, if it's within scope. Same thing for customer resource management, at least in FTC side. I assume also with CFPB, they're going to be requesting things like consumer complaints and conversation with their consumers. And to the extent that you have auto deletion policies in place, I know oftentimes those get held longer than your emails might, just because you're doing those for sort of ongoing customer service issues that you need for your business. To the extent that there are deletion policies, that's again going to likely, at least for an FTC investigation, going to need to be suspended. And
Chris,
how
can I jump in for one sec? Because I think this is really important. And I want to make a comment and then ask you a question about this, because the SEC, we have found over the last 10 or so years, maybe 15, has been looking at your policies and procedures and seeing whether or not you're following them as well in this area. So not only are you going to want to have clean policies and procedures, but you're going to want to actually be following them. And I find in document retention policies, or you can think of them as document destruction policies, that do allow you to, at a certain point in time, get rid of documentation. That is incredibly useful for companies, but I have found that a lot of our clients aren't necessarily following them in the way they're written. And it's because one arm is writing the policies and procedures and another arm's actually doing the IT technical work that either does throw stuff away or doesn't. And that can be a real issue for folks at the SEC. If you're not following your own policies and procedures, sometimes they try to lump that into a larger compliance problem. And sometimes they try to go right to document destruction. Were you purposely destroying documents outside of your policy because of this case? It can turn into obstruction. It can turn into some really hairy and difficult situations. Are you seeing that at all, or are you as well in your groups? We've been seeing that a lot lately in the last many years.
I haven't seen that specific issue, but I'll say just from an attitudinal standpoint, like if this is an issue that comes up, and like you go and you say, oh, we're just not finding anything that goes further back than this. And they say, well, why? And then they sort of, this is just like you're picking at the wall and you sort of keep going. There is, to a certain extent at these agencies, a skepticism of our clients. And it's just, these are people who've chosen to take this position in government likely for a reason. And so
I always say that they're cops on the beat too, right? When
the FTC are cops without guns.
You just see fraud and fraud and fraud all the time. You start to believe that everyone's doing nefarious deeds.
You see, when you work in UDAP, you see UDAPs everywhere. Right. Fortunately, the FTC can't send any people to jail, or at least they can. But Ori, are you seeing that too?
Regular requests for your document retention policies and procedures. There's sort of standard requests in every CFPB CID. I have not seen them get on companies for not following those requests, though. I think, again, if you can't produce things, then they're going to want to understand why and look back at your policies. And I think they're going to be, though, more concerned about intentional destruction as opposed to like, oh, well, it said 5 years, but really it happens at 3 and we never updated our policies. That's not what they're going to get hung up on.
Yeah,
it's also worth saying to this group while we're here that I had a company that's in a very specific area of the financial industry that was deleting its instant messaging every 6 weeks, and it had an ability to do so. Sort of legally vetted this. It had a policy and procedure. It did it for reasons, and it was doing that. And the agency SEC certainly wanted all of the text messages that the company's server had, which is different than many of the other text messages. And we gave them all the text messages that were relevant and responsive from the company server, which was very, very little. And then we went into a discussion about what the policy was, why it was there. And once it was explained in full and vetted, and they saw that there was legal counsel, an advice of counsel on that this could be done, they went away on the issue and never came back. So there is real utility in having a thought through strong policy here at the end of the day that can really cut off certain things that you don't necessarily want to have to, at least, not that you've done bad things, but this cuts off potential avenues of inquiry, even if they're not going to be fruitful.
Yeah, no, that's totally right. Well, we're going to go on to the next slide, but this is where you can get into the classic like discovery over discovery, which is, at least from me as like a civil litigator standpoint, is like the hellscape of litigation. So like let's God forbid we can avoid that, because it's just
the illegal
unnecessary. It's unnecessary.
of
It's
litigation.
unnecessary cost at the end of the day, and it's incredibly expensive.
Right.
So now the last thing on the early stages is just deadlines, and so I know that like one thing you'll see, obviously, you want to know, so it's what are they asking? Am I the target? Like what do we need to do for the documents? And then this is like, when do we need to? This is the important when. And every CID subpoena is going to have a deadline. There's going to be a deadline. It's going to say produced by X, and given, depending on how invasive, expansive the subpoena is, it will be wildly unrealistic. And for the large extent, most of the agencies understand that, even if they won't say it during your meet and confer, they'll say this is a reasonable subpoena and we expect a response by the deadline. But what will often happen, that's an expectation, is that you're going to have a meet and confer with the government, even if they won't negotiate the actual terms of the CID, like what top documents are actually going to produce. Almost, at least in FTC productions, in any reasonably complex case, you're going to propose and negotiate a rolling production schedule. There are, like, formal, at least in FTC land, formal deadlines to confer with the government and to raise objections. And these are like formal deadlines if you are planning on filing within the agency a petition to quash the CID in some way, shape, or form. Now, quite honestly, unless something has gone wildly off the rails, that's almost never a fruitful strategy. I mean, if you look through like the graveyard of petitions to quash CIDs, they're rarely granted and have the added downside of essentially disclosing the existence of the investigation, because the decision to quash the CID will become a public decision. So that's something to keep aware of. And the one thing I want to say, just this is mostly from an FTC standpoint, is that in connection with extension requests, the FTC now, it is standard fare for them to request tolling agreements. And the standard FTC tolling agreement is not like, you have your production, you have your reasonable production schedule, it tolls from the original deadline until when the production ends. These are more often, the initial ask is toll until the end of time. So it's sort of it's a penny in, a lot more than a pound out, in terms of
that we do not have. But we do tolling agreements. We have tons of that. Typically, I've got one now that's 6 months, and it's been every 6 months they come back, and we're now 2.5 years later. They've done almost nothing substantive in 2.5 years, but they are keeping it alive and refusing to close it. And so we hear from them every 6 months just to re-up the tolling agreement. But we tend not to have tolling agreements that last forever. Ori, I'm more interested in the CFPB. In my experience, the deadlines are more solid for the CFPB. The SEC, they're always negotiable, because unless they're going to take you to court and enforce the subpoena, which they're almost never going to do, they give you that, if you say I need more time, you need more time. And they may get angry, they may be disappointed, but at a certain point in time, they're going to want it. But it's very rare that they're going to enforce dates. In talking to you, it sounds like the CFPB is much more formulaic.
Well, I think that the CFPB in general, their starting point is what's in the CID, we mean it, right? Nothing is really just a placeholder or pretend, as opposed to other agencies that includes lots of requests that you can get them to set aside in the beginning. That said, every CID has negotiated production dates, and they do agree to it. And at the end of the day, the CID isn't self-enforcing. So if you don't produce something, you haven't violated the law. The agency has to sue you to enforce the CID, and that's resources, and they don't want to do that either. So, that has a harm to your relationship in the course of an investigation if you're blowing past your deadlines. But if you blow past the deadline, nothing's going to happen to you other than that you'll piss them off. So it's yes and no. They're very strict, but return dates for production are negotiable. The 10 days to meet and confer with them, somewhat flexible depending on the case, and if you've got a compelling reason, certainly if it's a large CID, and we'll talk about that in a little bit about what you need to be prepared for. The statute is the same as the FTC, so you have 20 days to file the petition to quash. I totally agree with Chris about, that's almost never the strategy you want to take. It does put you in a bind though, because your deadline for filing this petition with the agency to quash the CID is going to pass before you've gotten a substantive response from the agency as to whether they're going to pull back on some of their really outrageous demands. And so you can end up in this position where, like, well, hey, you didn't petition to quash, and they deny your demand to narrow the CID. The one thing I would say on deadlines and on the early stage, and this seems so obvious, but is don't sit on the subpoena because of denial or fear. And I've had a client do this, right, that just put it aside because they don't want to deal. And those first few days and those first few weeks are so critical because you have these deadlines and you really need to be getting a jump on it. And if you have not done anything with that for 10 days, and now you pick it up and are now just starting to talk to outside counsel, you are so far behind the ball. You're really harming your ability to have this meaningful engagement with the agency and be able to make your best case for why you need modifications, because you're coming to them late. You're not going to be as up to speed on the facts because you wasted all this time. So it's really, if this comes in, you're planning on a nice day, you got to stop everything and deal with this, get outside counsel, because there's going to be a lot of dead time over the coming months and years. But that first 2-3 weeks is going to be very, very intense because of these early deadlines.
No, that's right. And one thing I wanted to just answer, we got a question in the chat. I'll just answer it because it's topical and on tolling agreements. And Ori, I don't know, does CFPB do tolling agreements? I just wanted, because we didn't poll you on tolling agreements.
No, they do. I mean, it sort of depends, the case. It depends a little on the attorney. They're not indefinite ones. You can negotiate, and in response to the question, do you push back on them? It really depends. I mean, you can certainly push back if they're asking for a year. You say, let's give you 6 months where, you're going to do it again, but you got to sort of weigh what are the pros and cons. And if you're not going to give them a tolling agreement, they're not going to be as inclined to say, fine, you could take 3 months to produce those emails. So it's in what context is that request being made? What posture are you in with the agency in terms of what's the benefit to you of getting this tolling agreement? Because what are you going to get in return?
Yeah, no, I think the issue, I think, is all about risk, because as Rich said, these deadlines aren't self-enforcing. If you blow off a CID, there's no penalty. What they do is their remedy is to go to federal district court, may file a public miscellaneous action to enforce the CID, and what they get is just a judicial order saying you have to respond to the CID. And so that's sort of the context that you have to think of in the back of their mind, is that all they get at the end of the day is a better, more enforceable version of what they thought they already had when they sent you a CID in the mail earlier. So it's sort of really you're trying to figure out what you can get from the agency, but not so much that the agency is inclined to say, well, this is terrible, I might as well just go to court. And that's a balance. But on the tolling agreement, at least in FTC land, you can negotiate the terms of the tolling agreement within bounds. There are certain things they are never going to agree to. There are certain things that they will agree to. And frankly, it's all along the margins. And the chief litigation counsel of the FTC literally signs off on every modification that's made. So there's some uniformity and some little bit, but in terms of whether to sign a tolling agreement at all, it's all just about how willing you are to bear the risk that they will not grant you a formal extension. And if you just continue to produce along your proposed rolling production agreement, whether or not they're going to say, well, we'll just file a motion to compel in the interim. And I have not seen that be done, but that doesn't mean it won't happen.
But I'm going to jump in really quickly because I can't help it on that very same subject on the tolling agreement, because where I see them most of the time with a now, it's somewhere between 5 and 10 year statute for securities fraud. is towards the end of an investigation. It's 5 years along the line. DOJ or the SEC is getting antsy. They aren't all the way there themselves, or there's other things they want to do, or there's things you've suggested are just going to take a long time, and they don't want to lose the ability to bring a case if they want to. And so, so I'm just going to say this, the way I'll say it is this. So often at times I'll see a tolling agreement request in that scenario, and the request is really hinged to, we're just going to have to bring a claim against you, right? We are going to charge you in district court because we have no time, right? And if we want our claims to stand and last and not lose the first year of them, which may be some of the most important parts, we're going to have to charge you, and we don't want to yet. We're not even saying we will in the future, but you may force our hand to go literally to court against you. And that I have seen several times myself. I've seen them run into court and do it when they couldn't get a tolling agreement. Those are some of the strategic things you have to consider oftentimes when a tolling agreement comes up. But I don't want to belabor this point too long.
All right, let's move on to the next slide. I know we're short on time. So, you got the subpoena, you read it, you haven't ignored it, you're aware of the deadlines, and one of the first things you're going to have to do is reach out to the government. In the CFPB, and we've alluded to this, and the FTC as well, have a requirement. In CFPB, you have to have a meet and confer with the government within 10 days, which is really quick, right? That's 2 weeks from receipt of the CID to have what the CFPB expects is going to be a meaningful discussion with them about the CID, what you can and cannot produce, why, if you need more time, why you need more time. And just saying this is really broad and I need more time is not going to cut it. They really want details. The CFPB in particular will want somebody who's familiar with your data systems on, if there's requests for data or for email, so they can understand the kind of data that's maintained and how it's maintained and what it's going to take to pull it and search it and all of that. So back to my earlier point, this is why you want to get a head start on it, because before, if you're reaching out to the government, before you reach out to the government, you want to understand at the first instance, how much time do I need before I even have this meet and confer? Can I do it on day 10, or do I need to push it back a little? And certainly before you have that meet and confer, you need to really understand the facts. What information do you have? How burdensome is it? What doesn't exist? Are there things you can offer the government instead that are going to be less painful for you, that you think might, appease them? And that takes a lot of time and effort before you're having that discussion. And then you're going to have the meet and confer. You're going to talk about both substantive modifications, like, hey, this, was written as really, really broad. Can we narrow it substantively? Timing modifications that we talked about. And as I mentioned earlier, at least at the CFPB level, those aren't really placeholder requests. They're all going to, they'll be negotiated. They're open to negotiating, but they're starting with the presumption that what they've asked for is what they want. The other thing about the CFPB, and this really varies by agency and why it's important to have counsel that knows a particular agency's practice, is CFPB enforcement attorneys are completely disempowered on that during that meet and confer to agree to any modifications. They might tell you what they'll recommend. They'll say, okay, that sounds reasonable, but the formal modification is going to come after you send a formal letter outlining your request, and you get a formal response that's going to come from the deputy enforcement director who signed the CID. Obviously, the enforcement attorney's recommendations are going to carry a lot of weight. And so those meet and confer discussions are really important, because you want to get him or her to understand your position and agree with it so that you can get that modification, but you're not going to get it on the call. Chris, Rich, quickly on FTC and SEC practice, mindful of our time.
Chris, go ahead.
I'll echo the disempowerment point. Like when I was at the agency, I was always willing to negotiate or like talk about what was reasonable, et cetera, because I knew what I wanted to know and what I was interested in knowing, and willing to sort of push back things that I was sort of less interested in. But that's not everyone. But at the end of the day, I always had to say, well, like, management was not in the room, and so you need to go and talk to them. And that's frankly going to be like almost everything you're dealing with a lot of these agencies, is that any sort of, at least with the FTC, any sort of big picture request is going to require them to talk with some client who's outside of the room.
Not the SEC and DOJ. They are fully empowered. They make their own decisions, and you will negotiate with them, which actually makes in many ways it easier. There is no meet and confer. There is no formalized process. All you need to know is that every request for documents, every subpoena will be a 14-day deadline. Every once in a while, there's a difference than that, but I mean, 90-something% of them are a 14-day deadline. And then the key is to, I agree with Ori, get outside counsel who understands the agency, who will then call up and discuss what's happening. I think the key for the calls for the SEC is actually trying as much as possible subtly to get information from the staff about what they're most focused on, what they're most interested in. Because you can actually glean, if you can get them talking, you can often glean 50-60% of the time. 50% of the time, they just won't talk at all. It's on paper. Take a look and respond. Well, we understand you're going to need time. Talk to us about what it is. 50% of the time, they'll tell you what they're really looking for, what this is about. Every once in a while, I get an old friend of mine at the agency, and they will literally be like, Rich, look, it's an insider trading investigation. Here's what it's about. Here's everything you need to know. Get me that information. And I have literally done, it's fantastic. And actually a kind of smart way to do it. Most young attorneys at these agencies think they need to hide the ball and trick you into giving them information. As you've done it for more and more years, if you get people who've done it for a while, they're happy to tell you exactly what they want, because that is actually what they're most interested in. And they don't want an 18-wheeler full of documents that has nothing to do with what they're interested in. So oftentimes you can get them to actually talk to you. That's my one point here. But
Okay.
let's move on.
Next slide, please. So you talk to the government, now you need to start collecting the responsive information. And that first bullet is really true. This is one part law and one very large part project management. There's probably a lot of requests in the CID and the subpoena. You need to keep track of, where are these materials coming from? They might be coming from one source. They might be coming from multiple sources. Who's pulling them? When have they been provided to counsel? So you're going to want to have tracking charts, and it's very helpful to have someone inside who's sort of responsible for this. I mean, when we have large clients, they literally have a project manager who is assigned to overseeing the response, and that person helps both coordinate the production of documents, coordinate the various witness interviews that have to happen, because in order to pull the documents, you need to understand where they are, and in order to know where they are, you need to understand what happened. And one of the things that surprised me when I came from government to private practice was the fact that most of my clients didn't actually really know what happened. They kind of knew what happened, but they hadn't understandably spent the time to really dig in, ask the hard questions about how something came about, who was involved, where all this responsive information is. So there's a lot of information gathering before you're actually collecting documents. There's a lot of organization that's involved, and being organized up front is going to save you pain on the back end. You want lawyers involved. You want lawyers involved because that's going to protect privilege. If this should all be, is run by lawyers, it should be protected by attorney work product privilege. And you want to let your lawyers decide what is and isn't responsive, right? They're the experts. They know what the agencies are expecting and how these things play out. And you'd rather, I'd always rather my client give us more documents and we can say, look, A, B, and C, we don't have to produce, or, and D, we have an argument not to produce, here are the pros and cons, than have a business person make that judgment, him or herself, just because they're not well versed in the nuances of this and the precedent of this.
I'd just say on that last point, I'd never underestimate the power of outside counsel to say to the agency on a call, we have done a sound process, a reasonable process. I will tell you that we have looked for and given you what we found.
That's a really good point. I'm sorry to interrupt. I think that is a really good point. And we work really hard to maintain credibility with the agencies because of that very point. And you could do everything perfectly in-house, but they just don't know you, and they don't know that what you're doing, even if you do in a way that they do with reputable outside counsel. Sorry, Chris, to
And
jump
we've
in
all
on
been inside, right? There were lawyers out there that we didn't think were honest brokers, and that really matters when you come in for an investigation. So I think Ori just said it, but I take tremendous care that the agency understands that I'm an honest broker. I certainly advocate on behalf of my client. They understand the game, if you will. We are all doing our jobs, and as long as you do that appropriately and truly, I am willing to make statements, stipulations that say we have reasonably reviewed this, we have looked through all of this, here's what we've got. And yeah, at times we miss an email. If they're getting things from all sides, we don't have all sides. It does happen, but they have a sense of that too. When they have 99.9% of everything they're expecting from you, they understand that as well. Let's go to the next slide if that's okay. I'm going to do this really fast. I know that we all wanted to do really quickly, just make sure you remember that there are disclosure considerations. Ori alluded to confidentiality in the letter. That's how I just learned that from you, Ori, and CFPB correspondence. That's how you know if you're a third party or not. Now I'm fascinated. In the SEC, there is no confidentiality for their subpoena or their requests required, so you can talk to anyone about it. Don't forget, sometimes you have contractual obligations to speak to certain folks because there's a government investigation. Make sure you know what you're dealing with. Is it an informal inquiry, a formal investigation? How far along are you? If you're a public company, do you need to disclose that? You don't typically need to disclose until something called the Wells stage, but we're not going to go into all that detail today. And the only other thing I wanted to make sure that folks are thinking of at the beginning is don't forget your O&D insurance, your officer and director insurance, which will often cover extensive government investigations. There are often requirements to inform the insurance company that this is there from the very beginning, that this is out there. You don't necessarily have to do much more than that, but you have to inform them that you've received an investigation or an inquiry from the government, and just put them on notice. Otherwise, they can claim that you didn't necessarily follow all of the requirements for your insurance later. Anything else anyone wants to add? Otherwise, I think going to the next section is important. Let's go. Next slide. So communication with employees is also really important. It's very important. Sort of look. Young companies, often it's really scary if you've never received one of these before. Not only scary, but you've probably never used the feature of your Smarsh or Global Relay, or not picking any companies, all those types of companies that house your documentation. Have you ever used your search function before? That becomes really interesting and important to start working on quickly. It just does require significant sweat equity. Forget the cost of outside counsel. Not that you should forget it. It's often extensive. Forget the cost of the investigation and all the other things you're going to do. Just sweat equity often takes a significant amount of time, and there's lots of things at the very beginning to make sure you are paying attention to. I like at the bottom of this slide that the special consideration. Don't forget. There may be witnesses out there who aren't your employees. You have to think about that. There may be employees who are implicated. You have to consider whether or not they'll need their own counsel. And outside counsel can help you make those decisions as well. But most importantly, for employees, go back to you want a document hold notice, which we said a couple of slides earlier, and you're going to want to be thinking about what group of employees is actually implicated, who needs to know about this investigation. Sure, you can send it to everyone, but that's typically not a great way to sort of keep this. SC investigations are confidential and non-public. It doesn't mean you have to keep them confidential, but they don't have to become public. And if you want to keep them as contained as possible, only talking to the employees that are implicated by the investigation or really need to know that they need to maintain documentation because the other 3/4 of your employees have never touched this particular transaction and are never going to be part of this investigation. They don't need to know. That's an important way to be thinking about your employees as well. Chris?
Yeah, no, I didn't have anything else there. I mean, really, it's
Yeah.
just the one thing I'll note before going on to the next slide is that the FTC has a pretty rigorous practice of individual liability. So this is generally for your higher level employees, but if given that that might be in the ether, that's just going to be something that's just from a personnel management standpoint. Just people are nervous about getting a subpoena. People are also nervous for potential liability issues. And so that's something, but I think we should probably go to the next slide.
Well, we're up against it. It's 2:30, but so let's take a couple of minutes and just blow through the other concepts here.
Yes. So it's on this we've talked about the first part about document production. Here, the only thing to highlight is testimony. Most of the agencies have authority to take depositions in the course of their matters. It's more common in some rather than others. It seems like in my experience, the SEC is more likely to take testimony. The FTC most often doesn't, although they did spend a lot of money when I was there for deposition skills training, which could highlight where they want to go with that, or at least to make sure people can. Or is there anything else on that?
I'll just make two quick points from the CFPB perspective. First, on the document production, that first bullet about agency-specific expectations regarding scope and mechanics. As with everything else we've discussed, the CFPB are sticklers, and every CID or subpoena is going to come with some technical specifications about how you need to collect documents and maintain their metadata. The CFPB actually cares about this. So you can't just produce like, here's the PDF version of our file that I pulled from my computer. It's, I want every version, and you need to collect it in a way that preserves the metadata. So you need counsel who, it's not complicated, but I can't remember if it's copy and paste or cut and paste. One of those messes up the metadata, the other one doesn't. So you want to make sure you're dealing with folks who know what they're doing and what the agency is expecting. The CFPB does generally take testimony in the course of investigations. In most investigations, there's going to be at least one, if not more, witnesses whose testimony is taken. Next slide. So a few other considerations before we wrap up. One is whether or not you want to conduct a full-blown internal investigation. And I'll just say, right, responding to a subpoena entails an investigation, right? It's not just, oh, well, they asked for, these 4 sets of documents, let's pull them. You want to understand what happened, why it happened, so that you can make sure that A, you're accurately representing things to the government, and B, make the best case you can to the government if there really is a problem. The three of us had a long and interesting discussion about whether you want to have a more formal internal investigation conducted either by the same or other counsel that's going to more deeply look into things. I think we're probably don't have the time to rehash that discussion now, so I'm going to keep going and let Rich jump in when I'm done with the slide. If there has been a problem, then you face the choice of, do you change your practices while the investigation's ongoing? And the benefits of doing that, certainly if it's a clear violation of law, is you're stop the bleeding, right? Cut off your liability because you're stopping the bad conduct sooner. That can look good for the government, shows that you're responsible. And, mea culpa, we just realized this wasn't intentional. We're going to stop it. We're going to remediate impacted and harmed consumers. The cons of doing it are that it makes you look guilty, right? It's essentially an admission that something was wrong. Now it can be couched in different ways of like, we think this is perfectly fine. Obviously, you don't like this, Mr. Regulator, so we're going to change our practices. But depending on the fact, you need to think about that carefully. And then, as alluded to earlier on, right, there's not just the risk of the investigation. There's third-party risk. There's consumer class actions in certainly in the consumer financial services space. There's derivative actions. We've seen derivative actions against companies, even for investigations that were closed with no finding, because they still cost the company a lot of money in just defending that investigation. So a few last points. I don't know if Chris or Rich had anything quick you wanted to add on this before we turn it over to the last slide.
No.
So I think we go to the next slide if you're okay with that, Ori.
Yep.
And I think we just, The only thing I want to say on here is, and there's lots to say, is that the investigations could just last years. So get ready for that. There's real sweat equity. I think if we go 2 slides forward, we wanted to make sure we gave you at least an overview of what the different agencies do, how they do it when you first get that that inquiry, that subpoena, that CID in the door, what to do. You've heard it from us. These are all things to think of and all those considerations you want to take. Any of us are happy to talk about any of those things individually for each of our agencies. You can see that we work together and talk about these things all the time amongst ourselves, and happy to pull each other on any of this. Feel free to reach out to any of us. I think that's it for us today. And I thanks so much for everyone's attention and time. And Ori, Chris, it was a pleasure.
Thank you all.
Thanks so much.
Thanks for listening.
Thank you.
Take care.
Bye, guys.
Bye-bye.